Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. This is Substantive Spotlight, where today we're diving into the world of discovery, the phase of litigation where parties dig for facts, uncover evidence, and occasionally find a few skeletons in the closet. Think of it as legal archaeology, where instead of dinosaur bones, you're hunting for smoking guns and paper trails. Discovery isn't just about satisfying curiosity. It's the engine that drives litigation forward. Did you know that the vast majority of cases settle during or right after discovery? That's because once all cards are on the table, parties often realize their best move is to negotiate rather than roll the dice at trial. Today, we're unpacking everything you need to know about discovery for your civil procedure class in the bar exam. So first, let's start with the scope of discovery. Here's a fundamental question. What information can you actually discover? Federal Rule of Civil Procedure 26b1 tells us that parties may obtain discovery regarding any non-privileged matter that is 1, relevant to any party's claim or defense, and 2, proportional to the needs of the case. Relevance here is broader than what you see at trial. Information doesn't need to be admissible to be discoverable, just reasonably calculated to lead to admissible evidence. It's like casting a wider net when fishing. You might throw some catches back, but you want to survey the whole area. But there are limits. Proportionality is the brake pedal on discovery requests. Courts consider the importance of the issues at stake, the amount in controversy, parties' relative access to information, parties' resources, the importance of the discovery in resolving issues, and whether the burden outweighs the likely benefit. Think of proportionality as a cost-benefit analysis. Is what you're likely to find worth the time, effort, and expense required to find it? Then there are privilege limitations. Attorney-client communications, off limits. Work product doctrine, that shields materials prepared in anticipation of litigation. It's like having certain rooms in your house declared private during an open house. Visitors can look around, but some doors remain closed. Now, let's not forget about initial disclosures, the information parties must share without even being asked. Under Rule 26A, each party must provide the names and contact information of potential witnesses, a copy or description of documents they may use, computation of damages, and insurance agreements that might satisfy a judgment. This automatic exchange is like everyone placing their opening poker chips on the table before the game begins. It ensures a basic level of transparency from the outset. Now that we know what's discoverable, let's talk about how to discover it. Think of discovery tools as different instruments in your legal orchestra. Each has a unique sound and purpose. First up, interrogatories. These are written questions sent to another party who must answer under oath. They're perfect for getting basic information and positions clarified. But use them wisely. Rule 33 limits you to just 25 interrogatories, including subparts, without court permission. It's like having a limited number of questions for a celebrity Q&A. Make each one count. Next, depositions, the face-to-face questioning of witnesses under oath. These are particularly powerful because they allow for follow-up questions and assessment of demeanor. Under Rule 30, each deposition is limited to 1 day of 7 hours, and you're capped at 10 depositions per side without court permission. Remember, in a deposition, there's no judge present to rule on objections except for privilege, making it a relatively unfettered exploration of facts. Document requests allow you to ask for relevant documents, electronically stored information, ESI, or tangible things in another party's possession or control. With the explosion of electronic communications, these requests can yield thousands of emails, text messages, and files. It's like asking someone to empty their file cabinets, hard drives, and phone records all at once. Don't forget about requests for admission. These ask another party to admit the truth of certain statements for purposes of the pending action. They're great for narrowing issues and establishing undisputed facts. Think of them as trying to get an agreement on the basic pieces of the puzzle so you can focus on the disputed parts. For specialized information, Rule 35 allows physical or mental examinations of parties whose condition is in controversy, but only with court permission and good cause shown. This higher threshold makes sense. Medical privacy is a big deal, and courts don't want parties subjected to unnecessary examinations. Now, in an ideal world, discovery would proceed smoothly with everyone playing by the rules. But in reality, let's just say things get messy. When parties don't comply with discovery obligations, the discovery dispute resolution process kicks in. Motions to compel are the discovery equivalent of telling the teacher that someone isn't sharing. If a party fails to respond properly to discovery requests, you can ask the court to order compliance. But first, you must meet and confer in good faith. No running to the judge without trying to work it out yourself. On the flip side, protective orders under Rule 26C shield parties from discovery that causes annoyance, embarrassment, oppression, or undue burden or expense. It's like having a referee you can call when the other side's discovery requests cross the line. Electronically stored information presents its own challenges. When litigation is reasonably anticipated, parties must take steps to preserve relevant ESI or risk spoliation sanctions. Accidentally deleted those emails? Well, the court might instruct the jury to assume they contained damaging information. Ouch. Speaking of sanctions, Rule 37 gives courts a range of options for dealing with discovery misconduct, from ordering payment of expenses to striking pleadings or even entering a default judgment in extreme cases. The message is clear: take your discovery obligations very seriously. Now, discovery isn't just about following the rules. It's about strategy. Like a chess game, your opening moves can set the tone for the entire litigation. Consider your discovery plan carefully. What do you need to prove your case? What information does the opposing party likely have? Which discovery tools will most efficiently get you what you need? Timing matters too. Some requests make more sense early, while others are better after you have basic information. Know when to push and when to compromise. Fighting over every document might burn bridges and goodwill with the court. Remember, judges don't enjoy refereeing discovery disputes. They want you to work things out like grown-ups. For bar exam purposes, when you see a discovery question, ask yourself these questions. Is the information sought within the scope of discovery? Is the discovery method being used properly? Are there any privilege or work product issues? Have procedural requirements been followed? If there's a dispute, what's the proper resolution? Let me give you a practical example. Imagine a personal injury case where Plaintiff Pat requests all safety reports for the past 50 years from defendant company. The company objects, claiming the request is overbroad and disproportionate. Who's right? The court would likely find the 50-year timeframe excessive, but might order production of a more reasonable period, perhaps 5 to 10 years, or reports related to similar incidents. It's all about finding that proportionality sweet spot. Now, discovery doesn't happen in a vacuum. It's carefully choreographed within the litigation timeline. After initial pleadings, the parties must meet for the Rule 26F conference to develop a proposed discovery plan. This happens at least 21 days before the Rule 16 scheduling conference with the judge. Initial disclosures must be made within 14 days after the Rule 26F conference, unless the parties stipulate or the court orders otherwise. Most other discovery can't begin until after this conference, creating a structured approach to information exchange. The court scheduling order will set deadlines for completing discovery, typically months, not years. Once that discovery cutoff date passes, you're generally out of luck if you still need information. It's like a store closing. Once the doors are locked, you can't get back in the shop. For a deeper dive into these discovery topics, check out our Listen and Learn episodes. We will link to them in the show notes. Episode 204 covers the scope of discovery and work product privilege. Episode 237 tackles initial disclosures, Rule 26F conferences, and depositions. And episodes like our Discovery Part 2 podcast cover motions to compel, interrogatories, and physical and mental examinations. Until next time, this is your substantive spotlight on civil procedure, where discovery reveals what really happened. Thank you so much for watching. Give us a like, leave us a comment, and subscribe so you don't miss any future episodes. If you'd like to learn more about what we do, check out lawschooltoolbox.com.